which is clauses 16 and 17, and schedules 1 and 2. So the question is that part 2 stand apart.
Mr. Chair.
Honourable Michael Woodhouse.
Thank you, Mr. Chair. I want to take a very short call on what is a very short part and should not require too much detailed debate, given that the substantive effect that this has given agreement to has already been addressed in part 1. But I do want to take the opportunity to address some of the comments made by members Logie and Cunliffe in respect of how the detention provisions that the warrants to which Part 2 refers are in some way a breach of the Bill of Rights, and Ms Logie mentioned that they were also contrary to the Human Rights Act and the Refugee Convention. I think Mr Cunliffe mentioned a heinous or egregious breach of the New Zealand Bill of Rights Act, which I find rather interesting because, of course, the Attorney-General is required to make such a comment if indeed it is felt by the finest legal minds in the nation that that were the case. In pointing this out, I'm under no illusions that I'm going to change the minds of Ms Logie and Mr Cunliffe. A mind of sanctimony is a hard one to change, but indeed the Attorney-General, having given very, very careful consideration to whether this bill did breach the Bill of Rights, as he is required to under Section 7, I think it is, of that Act, did not do so. Nor did the Justice officials, nor did any of the other officials supplying the information to the committee. So what Mr Cunliffe is saying is that he knows better than the finest legal minds in the country. He knows better than all of that. Now, I don't think anybody could say that Mr Finlayson is anything other than straight up and down the line when it comes to his obligations under Section 7 of the Bill of Rights Act. And yet he, having taken the best advice and having looked at this bill in its entirety, decided that it wasn't a breach. And indeed, the bill, when it was reviewed, the Justice Ministry pointed out that detention is not and does not become arbitrary. A district court judge has to be satisfied that detention is necessary, and it enables the judge to issue a warrant for a shorter period of time than sought, or to revert, and I think this was a recommendation of the committee, back to an individual warrant of commitment when the judge is not satisfied that a group warrant is necessary. So I utterly reject all the shaking of the heads isn't going to change this, and certainly I don't expect they'll change Ms Logie's mind, because I rely on better legal advice than the skewed opinion of Ms Logie and certainly Mr Cunliffe, who I believe is a lawyer and should know better. This is not, well, thank goodness for that. At least he's got some out, because that would be a bit of a travesty on the legal profession if that was the extent of his legal knowledge. This is not a breach of the Bill of Rights. This is not a breach of any of those conventions that this government takes extremely seriously.
Darian Fenton.
Thank you very much, Mr Chair. Well, I want